Good afternoon, everybody. This is Attorney Marjorie Brunelli, and today I'm going to explain a little bit about attorney's fees. That's, I think, one question that every attorney gets, either in the beginning of the call, at the end of the call. And how much is this going to cost me? How do you work? Do you take this case on contingency fee? What's happening? Can I afford to hire you? So I'm going to explain a little bit how it works. If it's a simple case, let's suppose you need a demand letter. There's a dispute, a landlord-tenant dispute, or I don't know, some issue with a contract or a contractual issue, or something minor. You need a small claims lawsuit, or something simple, a simple contract that needs to be reviewed. For those types of cases, depending on the contract, some contracts are on an hourly basis because they're complicated. But depending on the case, if it's simple enough, it can be a flat fee. So I'll just tell you, I don't know, for this thing, I think I'm probably going to expend this amount of time, and I think a flat fee of this much is sufficient. But the majority of the cases are on an hourly basis, and that's when you're going to hear about the retainer agreement. Well, the retainer agreement or the engagement letter is the contract for services that you're going to sign with the attorney that you're going to be hiring anyways. The retainer deposit is the deposit that you're going to make with the attorney's trust account. And each attorney works in a different way. So they'll tell you, I need a 10-hour deposit, 15, 20, 30-hour deposit. It depends on the case. Sometimes the case is already more complicated because it's already in the middle of the lawsuit and you decided to change attorneys. So maybe they'll make the deposit a little bit more, and the attorney is going to require more hours than if the attorney was the one initiating the case. So it all depends on the situation. But so then you deposit, whatever the hourly rate for that attorney is, times the amount of hours is the deposit that you're going to be making. And then as the attorney works the case, he keeps track of all his billable entries, his billable hours, and he will send you a detailed invoice at the end of the month. I do it once a month. Obviously, you can ask the attorney to do it every 2 weeks, or how often you think is necessary, but generally it's once a month. So once a month you're gonna get that invoice showing, okay, out of the 20-hour deposit, the attorney already used 10 and I have a 10-hour credit. So the attorney will keep working on the case, and once the hours expire and the case is still pending, obviously you're gonna have to make another deposit. So that's the way that it works on an hourly basis. The contingency option is when the attorney decides to take your case and take the risk of only getting paid if he recovers on your behalf. Then he would be entitled to a percentage of the case. I do not work with contingency fees. I'm a sole practitioner. I work by myself, and I do not have the financial capability of taking that sort of risk and working on a case without a retainer or a flat fee deposit. Generally, it's the medium to large size firms that work with contingency fee cases. Obviously, it depends on the area of practice. I do a lot of family law and also business law with a little bit of real estate. So that might be different for an attorney who works with medical malpractice or personal injury. In those situations, it's probably more common to have a percentage, not in my situation. So it's gonna vary depending on the area of practice of the attorney, and also the size of the firm and the risk that they can take in taking a case and not getting paid up front. The other option would be a hybrid contract. In that situation, the client would have to make a deposit, but a much smaller deposit, and then the attorney would be entitled to a percentage. So you can combine it. It'll be a combination of the hourly rate with the contingency. We call it a hybrid contract. So it's possible. I've done it, but on rare occasions. It depends on the type of case. Obviously, if I get a case that's a little bit larger than the everyday case, I do consider that depending on the client. So there are certain things that fall into consideration for the determination of the fees. The other thing that you have to pay attention to is the type of office that you're looking for, because there are small firms such as my firm, and it's just me, myself, and I. And when I need help, it's my preference to hire another attorney to co-counsel with me. I do have a receptionist, but it is not the same as a medium-sized law firm or a large law firm where they have a full staff available to them and multiple attorneys. I work by myself. So all of that is going to affect the overhead to the firm, and obviously all of those costs are passed on to the client. So, there are different considerations that you have to make in hiring attorneys. The same, I always say it's the same as in hiring a doctor. If you need surgery, you're going to go with the first doctor you speak to. No, that's not the case. You're going to look for a second opinion, a third opinion, and see who you trust and who you're more comfortable and you feel is more capable in your situation. So it's the same thing with any type of profession, the same thing with an attorney. I think you need to feel comfortable with the person that you're hiring, and obviously do your due diligence, make sure the person is capable professionally and has the capacity to take your case and the experience to give you a good result. And but those are the four types of contracts for the hiring of an attorney. And I just wanted to clarify, because I do get a lot of those questions, and sometimes clients get a little bit confused. It's like, oh, but you said it was a flat fee and now it's an hourly rate. That's another thing that sometimes happens. You get hired to do a demand letter, and then you do a flat fee, you do the demand letter, and a month later somebody files a lawsuit. So now it's a totally different situation, because now you need a retained deposit, and it's on an hourly basis because you're going into litigation. And most litigations are on an hourly basis, because there is no way for an attorney to predict how long the litigation is going to take, because it doesn't depend only on us, it depends on the other side, and it depends on the judge as well. So that's the simple explanation. I hope it helps. And obviously, if you have any other questions, feel free to contact me. All my contact information is up in the bio. Thank you and have a great day.